The certified letter arrived on a Thursday afternoon, thick with legal language I had to read 3 times to fully absorb, informing my family that Hartwell Meadows Homeowners Association had initiated formal foreclosure proceedings against our property based on accumulated fines exceeding $4,000, the entire dispute originating from a single solar-powered light fixture, roughly the size of a deck of cards, mounted at the base of my son's wheelchair ramp to help him see the transition point safely after dark. My name is Farouk Delacroix Nwasu. My son Emil is 14, and a car accident 3 years ago left him with a spinal cord injury that requires him to use a wheelchair full-time. My wife Odalise and I installed a ramp at our home side entrance the following year, approved through a formal disability accommodation request under the Fair Housing Act, and about 8 months after that, once Emil started attending evening tutoring sessions that had him returning home after dark several nights a week, we added a small, unobtrusive solar-powered light at the ramp's base, specifically so he could see the exact spot where the ramp surface transitioned to the ground. A genuine safety necessity, given how easily a wheelchair's front casters can catch on an uneven transition point in low light. I want to establish clearly, because it matters enormously for everything that follows, that we did not consider this light installation to require any additional HOA approval beyond what the ramp itself had already received. It was a small, battery-powered, code-compliant fixture, no wiring, no permanent structural modification, nothing that would ordinarily require architectural review under any reasonable reading of our community's governing declaration. The woman who decided otherwise was Priscilla Ashworth Vandermeer, president of the Hartwell Meadows Board for just under 2 years by the time this dispute began. I want to walk you through how her tenure had unfolded leading up to this point, because the pattern matters enormously for understanding how something this disproportionate ever escalated to formal foreclosure proceedings over what amounted to a nightlight. Priscilla's presidency had been marked, from fairly early on, by an aggressive enforcement style that several neighbors described to me, independently, as unusually rigid even by typical HOA standards. Disputes over minor landscaping variations, holiday decoration timing, small details that most boards would address with a friendly reminder rather than escalating fines. Our ramp light became her target about 10 months into her term, when I received an initial citation describing it as an unauthorized exterior lighting fixture that violated our declaration's provision requiring board approval for any permanent or semi-permanent exterior illumination addition. I responded immediately, explaining that the light was a safety necessity directly connected to Emil's existing, formally approved disability accommodation, and that as a battery-powered, non-wired fixture, it fell well outside what any reasonable interpretation of permanent exterior illumination was intended to address. Priscilla's response, delivered about 2 weeks later, did not address that argument directly, stating only that the board's interpretation of the provision extended to any exterior lighting device regardless of its power source or method of installation, and that I had 14 days to remove it or face escalating fines beginning at $50 per day. I want to walk you through the decision I made at that point, because I think it matters for understanding how this situation grew as large as it eventually did. I did not remove the light. I made the decision, alongside Odalise, that a genuine safety necessity for our disabled son was not something we were willing to compromise on over what struck us as an obviously unreasonable and unsupported interpretation of a vague declaration clause, and I submitted a formal written accommodation request specifically addressing the light itself. Citing the Fair Housing Act directly, and including a letter from Emil's physical therapist, explaining the specific safety necessity of adequate illumination at the ramp's transition point given his particular mobility limitations. Priscilla's board never formally responded to that accommodation request at all. Instead, the $50 daily fines simply continued accumulating, week after week, month after month, with no further correspondence addressing the substance of our disability accommodation argument. Until, by the time that certified foreclosure notice arrived nearly 8 months later, the accumulated fines, compounded with additional late fees and administrative charges the HOA had tacked on, had reached just over $4,000. A sum, the letter informed us, the association intended to pursue through formal lien foreclosure proceedings, if not paid in full within 30 days. I want to tell you about the specific quality of disbelief I felt reading that letter, because it took me a genuinely long time to accept that an HOA board could actually be attempting to foreclose on our family's home over an unresolved dispute about a wheelchair ramp nightlight. I called an attorney the same afternoon, a man named Bartholomew Okonkwo Ferreira, who a colleague had recommended, specializing in property and disability rights law, and I want to tell you, his reaction on our very first call told me everything I needed to know about how seriously this needed to be taken. "Farrokh," he said, "I want you to understand two things immediately. First, we are absolutely going to stop this foreclosure, because what you're describing is, on its face, retaliation against a family for asserting a federally protected disability accommodation right, and that is not something any court is going to look at kindly once the full timeline is laid out. Second, and I want you to really hear this part, the fact that they never formally responded to your written accommodation request at all, simply continuing to assess fines in silence, is itself a serious compounding factor, because federal fair housing regulations require associations to engage in what's called an interactive process when a resident requests an accommodation, and simply ignoring the request while continuing enforcement action is, in itself, often treated as a separate violation. Bartholomew filed an immediate legal response halting the foreclosure proceedings, citing the pending, unresolved accommodation request and the association's documented failure to engage in any interactive process regarding it, a filing that succeeded in freezing the foreclosure timeline while the underlying dispute could be properly addressed. But Bartholomew told me something else during that same conversation that reframed the scope of what we were dealing with entirely. "I want to look into whether this is an isolated overreach specific to your family," he said, "or whether there's a broader pattern here, because foreclosure over a $4,000 fine balance stemming from a disputed nightlight is disproportionate enough that I have real questions about whether this board's overall fine escalation practices might be worth a look from the State Attorney General's Consumer Protection Division, which handles exactly this kind of predatory HOA enforcement pattern when it rises to a certain scale." What Bartholomew found over the following month, requesting the HOA's complete fine and foreclosure records through a formal discovery process tied to our own legal defense, revealed something considerably more troubling than a single disproportionate dispute over Emil's safety light, a pattern of aggressive fine escalation and foreclosure threats that, once fully documented, would end up drawing the direct attention of our state's Attorney General, and would ultimately expose exactly how many other families across Hartwell Meadows had been quietly pushed toward the same devastating threat we had just barely managed to stop in time. Bartholomew's discovery request returned records covering the entirety of Priscilla's 2-year tenure as board president, and what those records revealed, once he'd finished cataloging them, was a pattern of fine escalation and foreclosure threats affecting considerably more households than just our own. Across that 2-year period, the association had initiated formal foreclosure proceedings against 11 separate homes, based on accumulated fine balances that, in nearly every case, had originated from disputes over relatively minor violations, a fence stain deemed slightly off the approved palette, a landscaping choice deemed inconsistent with community standards, a mailbox post style that didn't match, none of which, on their own, would typically justify the kind of escalating daily fines that eventually compounded into foreclosure-threatening sums. What struck Bartholomew most, reviewing the full pattern, was how consistently the association skipped what he described as reasonable intermediate enforcement steps. A courtesy reminder, a single warning fine, a genuine opportunity for resolution before fines began compounding daily, moving instead in case after case, directly to aggressive daily fine assessments that, left unaddressed for even a few months, could realistically accumulate into thousands of dollars. An amount that then triggered the association's own governing document provisions, allowing foreclosure action once a certain balance threshold was reached. This isn't an enforcement pattern, Bartholomew told me, laying out the 11 cases across his conference table. This looks like a system specifically structured to generate foreclosure-triggering balances as quickly as possible, whether or not the underlying violation actually merits that level of consequence. And your case, involving a disability accommodation that the board never even formally responded to, is actually one of the clearer examples of how disproportionate and procedurally deficient this entire enforcement structure has become. Bartholomew filed a detailed complaint with our state attorney general's Consumer Protection Division, which maintains, in our state, specific enforcement authority over predatory or abusive homeowners association practices, particularly patterns involving disproportionate fine escalation used to trigger foreclosure. The complaint included our own family's timeline, the pattern of 10 other affected households, and a specific emphasis on the failure to engage in any interactive accommodation process regarding Emil's safety light, framing our situation as a particularly severe example within a broader documented pattern of aggressive, procedurally deficient enforcement. I want to walk you through the investigation that followed, because the Attorney General's office moved with a level of thoroughness that genuinely surprised both Bartholomew and me, given how slowly some regulatory processes are known to move. An investigator named Rosalind H. Kowalski was assigned to the case, and her office issued formal record requests to the HOA's management company covering fine assessment practices, board meeting minutes discussing enforcement policy, and any documentation of resident accommodation requests, and the association's responses to them across the full period in question. What that broader investigation revealed, once Rosalind's office had compiled the complete picture, went beyond even what Bartholomew had already documented. Board meeting minutes from about 18 months earlier showed Priscilla explicitly proposing, and the board approving, a formal internal policy shifting away from the community's previous practice of issuing warning notices before fine assessment began, toward what the minutes described as immediate compliance enforcement, a change Priscilla had justified, according to the recorded discussion, as necessary to improve the association's fine revenue collection, language that, once entered into the state's formal investigative record, made unmistakably clear that the accelerated fine structure had been implemented, at least in part, as a deliberate revenue generation strategy rather than any genuine concern about community standards enforcement. I want to tell you about the moment Rosalind called to walk us through her office's preliminary findings, because it was the point at which this entire situation shifted from feeling like our own isolated, exhausting legal battle into something considerably larger and, in a strange way, more clarifying. This is a genuinely serious pattern, she told us. You have a board president who implemented a fine acceleration policy explicitly justified by revenue considerations, applied it against at least 11 households severe enough to trigger foreclosure proceedings, and in your family's specific case, ignored a formal federal disability accommodation request entirely, while continuing to assess fines against a safety necessity for a disabled minor. Our office intends to pursue formal enforcement action against the association, and I want you to know, this is going to matter for every other household affected by this same pattern, not just your own. The Attorney General's office filed a formal enforcement action against Hartwell Meadows Homeowners Association about 4 months later, alleging violations of state consumer protection statutes governing HOA fine and foreclosure practices, along with a specific federal fair housing violation tied to our family's disability accommodation request. I want to walk you through how this resolved, because the scope of the eventual settlement went well beyond anything Bartholomew or I had initially imagined when this started as nothing more than our own fight to keep our house. The settlement, finalized about 7 months after the initial foreclosure notice first arrived, required the association to immediately rescind all fines and halt all foreclosure proceedings across every one of the 11 affected households, refund any fines already collected as part of previously resolved cases, adopt a formal, Attorney General approved fine escalation policy requiring meaningful advance notice and a genuine opportunity for resolution before any daily fine accumulation could begin, and, specific to our own case, formally approve ML Safety Light as a permanent disability accommodation with an explicit written protection against any future challenge to it. I want to walk you through what happened to Priscilla personally, because the Attorney General's findings regarding her explicit revenue-motivated policy change carried consequences beyond simply losing her board position. She was formally removed from the board as part of the settlement terms, barred from serving in any HOA leadership capacity within the state for a period of 5 years under the terms of the consent agreement, and the association separately pursued its own internal claim against her for the legal costs the entire situation had generated, given that the Attorney General's findings established her personal role in implementing the policy that created this liability in the first place. I want to tell you about the day Bartholomew called to confirm the settlement was fully finalized, because I remember sitting with Odalys and Emil at our kitchen table, the same table where I had first read that certified foreclosure letter nearly a year earlier, and feeling something in my chest finally loosen after months of carrying a fear that, I'll admit, I hadn't fully let myself acknowledge until it was actually resolved. The genuine possibility of losing our home over what had started as nothing more than a small solar light, meant to help our son see safely in the dark. Emil, when we explained the resolution to him in terms appropriate for a 14-year-old dealing with enough of his own challenges already, mostly wanted to know whether the light was staying, a question I answered with genuine relief, telling him yes, permanently, with a formal written protection now in place ensuring no future board could ever challenge it again the way Priscilla had. If there's a lesson in this story, I think it's something Rosalind said to me during one of our final conversations before the settlement was formally entered, reflecting on the broader pattern her office's investigation had uncovered. She said that predatory enforcement patterns like this one survive specifically because individual families, facing an isolated dispute over a single fence stain or a single light fixture, rarely have the full picture of how many other households are quietly experiencing the exact same pattern, each one believing their own situation is an unfortunate, isolated overreach rather than part of a deliberate, revenue-driven structure operating across the entire community. The moment one family pushes back hard enough to draw genuine regulatory attention, the full scope of what's actually been happening tends to come into focus considerably faster than anyone running the scheme ever expects. We pushed back, and it turns out that one attorney willing to look past our own individual dispute toward the broader pattern, one state investigator with the authority and thoroughness to uncover exactly how deliberate that pattern had been, and one small, unassuming solar light at the base of my son's wheelchair ramp were more than enough to make sure Priscilla Ashworth Vandermeer's foreclosure machine never took another family's home again. Thumbnail text. She tried to foreclose over a NIGHTLIGHT.